D.C.
We are exactly 2 weeks out from the scheduled start of Donald Trump's first, possibly only, criminal trial. It's the one in New York, and the ex-president is seeking to derail it and delay it by any and all means possible. In court documents filed today, his lawyers argued that Manhattan District Attorney Alvin Bragg's case against Donald Trump should be paused until the Supreme Court weighs in on the scope of his so-called presidential immunity. They are set to hear arguments on that issue on April 25th. Trump's lawyers argue that prosecutors have suggested that they will introduce, quote, several types of evidence that implicate the concept of official acts for purposes of presidential immunity. Part of the potential evidence that they argue should be precluded from being used at trial include Trump's public statements about Michael Cohen, because they argue he made those statements in his official capacity as president. We're back with Andrew, Lisa, and Donna. Lisa, translate.
This is a Hail Mary to end all Hail Marys. We've got jury selection starting in 2 weeks. But more importantly, Nicole, I just want to take a step back and let our viewers know Donald Trump waived an immunity defense in this case months and months and months ago. He tried to float it in trying to get his case removed to federal court. It was soundly rejected by a federal judge. He initially tried to appeal, and when he realized that that appeal would conflict with arguments he was advancing in the 14th Amendment cases, he withdrew that appeal last November. And now, suddenly, 2 weeks until the start of jury selection, he's not saying he's immune from the entire suit because he knows he's waived that argument. What he's saying is because the state intends to introduce evidence about statements that he made when he was already president, this court should wait to hear the scope of his immunity defense, if any. We know that oral argument is not until April 25th. There is no valid presidential immunity defense as applied to Trump's tweets about Michael Cohen, for example. In fact, the entire case is about personal acts. It were things that Donald Trump did to disguise the fact that he had engaged in campaign finance violations with Michael Cohen and others, including the folks at the National Enquirer. There's nothing official about that. When you are acting in your capacity as a candidate and thereafter to cover up what you did as a candidate, that's inherently not official. And yet they are making this horribly specious argument and at the same time telling Judge Aileen Cannon in Florida that they need more time in her case. Why? Because they're going to trial on March 25th as they attempt to adjourn it. They are playing judges off of each other with a sort of casualness that's almost breathtaking.